Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire. There's no doubt the Supreme Court's Kashmir judgments of Monday the 11th are complicated and for some people very difficult to understand. They are, of course, widely anticipated and long expected, but that makes understanding them even more important. So joining me today to help explain the judgments is one of India's foremost senior judges of the Supreme Court, the highly regarded and well-regarded Justice Madan Lokur. Justice Lokur will help us both understand the judgments as well as their implications and indeed their complications. Justice Lokur, let me start with a simple general question. I'll come to details after that. How do you view, in an overall sense, the Kashmir judgments that were announced on Monday the 11th? Are you impressed by the judicial arguments they contain, or do you have reservations about some of the reasoning and its implications?
Yes, well, thank you, Karan. There are two or three things. One is that the case wasn't as complicated as the judgment makes it out to be. Right? I think that maybe 200 or maybe 250 pages of the judgment were not necessary, unless I've missed something. I have not been able to connect the dots or something. But I think maybe 200, 250 judgments could be straight away taken out. Now, you see, in a judgment, I would expect that when you are referring to something which is not readily available, the Constitution of India is readily available. A law enacted by Parliament is readily available. But when you're talking about a constitutional order which has been passed with reference to Jammu and Kashmir, that's not readily available. I mean, you have to go to the internet and get that. And some facts pertaining to the constitutional order, they were not a part of the judgment. So then it becomes very difficult, when you're reading the judgment and then you want to, refer to something, you have to go to your computer and try and look at the constitutional order and see what it says. So these are things which make it difficult to go through the judgment. Now, so far as the submissions are concerned and the reasoning is concerned, like I said, if you take out 200 or 250 pages, then it doesn't become so complicated. Then the issues get narrowed down. In fact, they were narrowed down at some part of the judgment. And if you look at it from that point of view, well, the reasoning, you could disagree with it, right? In any case, given the same facts, judges disagree.
So what you're saying in terms of your overall view is A, it could have been 200 pages shorter, which would have made it easier to understand. B, it could have referred to many of the things it talks about rather than requiring you to have to cross-reference them from computers. So it's neither easily written nor easy to fully follow.
Yes. In fact, it took me a long time to understand the judgment because it was so complicated. And then you keep going back and forth forth and back, you know.
So they've made it deliberately difficult to follow.
I don't know whether they made it deliberately difficult, but it is difficult to follow. Yeah.
Let's then, with that as the background, come to the details. And because they're complicated, as you say, I'll take the questions slowly, and more importantly, with your permission, I'll read the questions, because I think in this instance at least, terminology is important. I should be using the right words rather than just any word that fits in. Now, first of all, you've discovered that although the petitioners challenged the dissolution of the Assembly and the imposition of governor's rule, and the Supreme Court judgment acknowledges that both were challenged, the court actually failed to discuss the challenge and therefore to dispense with it. The petitioners had argued that an alternate government was viable and therefore the dissolution and governor's rule was unconstitutional. Had the Supreme Court agreed with this challenge, everything that followed the dissolution and governor's rule, such as president's rule, such as abrogation of Article 370, such as the reorganization of the state, all of that would have been invalid. So let me start by asking, was this a lapse on the Supreme Court's part not to directly challenge, not to directly tackle this challenge? And if it was a lapse, how serious a lapse was it?
You see, the Supreme Court notes in paragraph 19, I think, that the proclamation issued by the governor was under challenge. And I think in the same paragraph, or maybe a paragraph or two later, the Supreme Court notes that the proclamation issued by the president was also under challenge. Two proclamations, they were both under challenge. The Supreme Court doesn't say anything about dissolution of the assembly, right? So this is a fact which has not come on record, but I assume that the assembly was dissolved at some point of time because, they've given a direction that elections should be held. So I'm assuming that the assembly was dissolved at some point of time. Now, so far as the proclamation issued by the governor is concerned, the Supreme Court didn't go into it, Now, that was the first step, so to speak. The first thing that happened was, after the resignation of the chief minister, the judgment records that on the next day, the governor issued the proclamation.
Dissolving the assembly.
I don't know whether it was dissolving the assembly, but imposing governor's rule. Okay? So, once a governor's rule was imposed, the argument also of the petitioners was that, listen, we'd been telling the governor, even after the resignation, that, we can form the government. The coalition partner may have, backed out, but we can still form the government. Now, that opportunity does not seem to have been given by the governor. And the next day, governor's rule was imposed. Now, the argument was that there was no material before you to impose governor's rule. Why should you impose governor's rule when we can tell you that we are in a position to form the government? Give us a chance to, form the government. The Supreme Court didn't look into that, unfortunately. Now, with regard to the, and what the Supreme Court said was that, subsequent events were challenged. All right, subsequent events were challenged, but that doesn't mean that the challenge to the proclamation was given up. Then, with regard to the presidential proclamations, the Supreme Court says that, we're not looking into it, and they give 2 or 3 reasons. They say that,
I'll come to the presidential proclamations in a moment's time.
Yeah.
Let's first focus on the Supreme Court's failure to look into the governor's proclamation declaring governor's rule. As you pointed out, the Mehbooba Mufti in particular said the declaration of governor's rule is improper and unconstitutional because an alternate government can be formed.
Yes.
Give me time, I'll form it. She wasn't given time, and therefore governor's rule was imposed at a stage when an alternate could have been brought into being in the form of government. Therefore, it was wrong. And what you're saying, if I understand correctly, is if the Supreme Court had looked into the declaration of governor's rule, it could have concluded governor's rule was prematurely and wrongly declared. And if that's the case, everything that follows after governor's rule would become invalid. Therefore, abrogation of 370 would become invalid, and therefore reorganization of the states would become invalid.
Yeah.
So failure to look into governor's rule meant that you could have checked the process there and then, but they didn't.
Yes.
So it's a pretty serious lapse.
Yes. 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 You see, the next day, that's what it turns out, governor's rule was imposed. Okay, this was, if I remember correctly, sometime in June 18 or 19 or something. Now, the notifications that were under challenge, the constitutional orders, were issued on the 5th of August. So, between the 18th or 19th of June and the 5th of August, there was time, in theory, for somebody to form the government.
And that was the key of the challenge.
Yeah, yeah.
And by not looking at that challenge, the Supreme Court failed to take a step that might have led to the conclusion the abrogation was wrong, the reorganization was wrong. Because if a new government could be formed, there'd be no opportunity for any of these things.
Yes, yes.
So we're agreed this is a very serious lapse on the Supreme Court's part.
Yes.
Let's then come to the second important thing. This is the court's decision to uphold what is popularly called abrogation of Article 370. Now, this is particularly complicated, so I'll go through it very carefully with you. On the one hand, the majority judgment written by Chief Justice Chandrachud says that the critical part of Constitutional Order 272, which reads down Article 370's ultra vires, because it wrongly used Article 367 to interpret Constituent Assembly as a legislative assembly. And since the process that the government had used to abrogate 370 was precisely this process, the court should have actually struck down the abrogation, but it didn't. What the court instead said was that because Article 370 can be read down by use of Clause 3, therefore it upheld what the government did. And in effect, what that means is that the court ruled that what the government did was wrongly done, but if it had been done differently, it would have been correct, and therefore it gave the government the effective benefit of the doubt. Now, to my mind, that's a convoluted sort of logic. How do you view it?
Yeah. You see, the Constitutional Order 272, right? It had three things. If you don't mind, if I can just go through it. You see, it said, first of all, that the Constitution of India is applied in full to the state of Jammu and Kashmir, like it applies in full to every other state in the country. Second, it said that the expression Constituent Assembly in Clause 3 of Section 370 should be read as Legislative Assembly because of an amendment made in Article 367, which deals with the interpretation of the Constitution. The third thing which the Constitutional Order 272 says is that all past constitutional orders are obliterated or revoked or abrogated or whatever. Now, the Supreme Court said that you can't read Constituent Assembly to mean Legislative Assembly. Why can't you do that? Because you are then amending Clause 3 of Section 370, of Article 370. You cannot amend Clause 3 or even Article 370 without the consent of the state government. So, therefore, you can't read the Constituent Assembly to mean Legislative Assembly. But they said that, the Constitution of India can be applied in full to the state of Jammu and Kashmir. Now, I don't think that's correct, you see, because if that was correct, then why make this amendment?
Absolutely. And if the amendment is wrong, and the amendment is the basis upon which the government is trying to amend 370, then the attempt to amend 370 falls by the wayside.
Yes. I mean, Article 370 could not have been amended. Let's be clear about it. But there, I think the Supreme Court falters. They've come to some conclusions which I'm unable to understand how they've come to. For example, they say that it's all right if the Constitution of India is applied to the state of Jammu and Kashmir. Now, if it was so simple, it could have been done without all this rigmarole.
Absolutely.
You know?
And to my mind, and I'm not a layman, but the simple thing is the procedure that the government used to amend 370 was to reinterpret Constituent Assembly to make it Legislative Assembly.
Yeah.
The second the Supreme Court says that's ultra vires, then the procedure the government has used becomes ultra vires.
Yeah.
And therefore it follows that you must strike down what the government has done.
Right.
But they didn't. Instead,
Correct.
what they did was to say, you may have done what you wanted to do the wrong way, but there is, ahoy, another way of doing it,
Yeah.
which is to use Clause 3. If you'd used Clause 3, it would have been okay. They overlooked the fact that the government didn't use Clause 3, but gave them in a bizarre way the benefit of the doubt and said, had you used it, be okay. Therefore, we'll recognize what you've done, even if you didn't do it the right way, but there was another way of doing it that was the right way, and we'll accept that as the right way.
Yeah, I'm not sure if they went to that extent. You see, because Clause 3 could not have been amended. All right? Because they said that you can't amend Clause 3.
But there, forgive me interrupting you, sir, what they said, if I understand them correctly,
Yeah.
is that Clause 3 requires a recommendation from the state,
Yes.
right? But because
from
the
the
Constituent Assembly,
Yes.
and because the Constituent Assembly no longer exists, all that is now removed is the requirement for the recommendation. That doesn't, they say, stop the president still acting.
Yeah.
The president, they say, can still act even if he doesn't get the recommendation. All that's obliterated is that the recommendation can't come. So that was another sleight of hand that allowed them to say you can use Clause 3.
Yes. Yes. You see, but they don't say all this explicitly.
They imply it.
They imply it by saying that, well, under this 272 constitutional order, you could put the Constitution of India over there. Right? Now, if you could put the Constitution of India over there, there was no need for you to amend 370 clause.
Because it was already over there.
It was already over there. Right? Then at another place, when towards the conclusion, I think it's in paragraph 400 or something, they say that, Article 370 could have been abrogated or could have been revoked. Now, if it could have been revoked or abrogated or whatever expression they use, then they should have just done it.
Rather than have to go through the wrong interpretation route.
Yeah.
And this is the funny thing. When you find that the route the government has taken, which is to attempt to reinterpret a phrase Constituent Assembly to mean Legislative Assembly, and you come to the conclusion that is ultra vires, because that's the route the government's taken, the logical thing to do is to say, sorry, what you've done is wrong.
You're right. But they didn't say that.
No, and this is the bizarre bit.
Yeah.
And instead what they said was that there's another way of doing it via Clause 3. Clause 3 requires a recommendation from the Constituent Assembly, but they've argued, and I think the Chief Justice in his judgment argues, that because the Constituent Assembly doesn't exist, it can't give a recommendation. That invalidates the recommendation, but it doesn't invalidate the power of the President to act without a recommendation.
Yes. Now, but for
But
that...
that's bizarre.
Yeah, but for that, they don't use Article 370 Clause 3. They use Article 370 Clause 1.
Okay, to say the same thing.
To say the same thing.
But then don't we come to two strange conclusions? First of all, it seems as if they're putting arguments in the government's mouth and deeming their own arguments to be correct. And this, as Kapil Sibal in his tweet very famously said, I'm quoting his tweet, he says, the court's verdict had little to do with the government's own understanding of Article 370. The government's understanding hinged upon a reinterpretation of Constituent Assembly. The court's verdict didn't hinge upon that at all. It found the reinterpretation mala fide and ultra vires. They said the route is 371.
Yeah.
So in other words, they suggested to the government what the government could do, even though the government hadn't done it, and then presumed that if they had done it, it would be okay. Therefore, what the government's done is okay.
Yes. I'll put it slightly differently. You see, the case of the government was dependent upon the Constituent Assembly becoming the Legislative Assembly.
Ji.
That did not happen. Now, if that did not happen, then the case falls to the ground. What the government also seems to have done, or what the court seems to have done, I don't know if the government argued that. They said that the powers of the state assembly are with the governor. The powers of the governor are with the president. The president says, or parliament says, and president says that all right, you delete Article 370. So we delete Article 370. That's what the court says. Now, I'm not sure whether that was argued, because it could not have been argued. I would put it slightly differently. I would say that it could not have been argued because the case hinged upon the Constituent Assembly becoming the Legislative Assembly.
That's right.
There was, as far as I know, like I said, it's such a complicated judgment. As far as I know, and the alternative argument was not advanced.
And yet the Supreme Court's behaved as if it was.
Yes.
And this is what I mean.
Yes.
When I say the Supreme Court has effectively put words in the mouths of the government.
Yeah.
Because what the Supreme Court claims is the route you could do it by is not the route the government chose to do it by.
Yeah.
And the route the government chose to do it by, which is reinterpreting Constituent Assembly to mean Legislative Assembly, they struck down.
Yeah.
So in effect what they're saying to the government is, what you did the wrong way, and we ought really to be striking it down, but we won't, because there's another way of doing it, which you didn't choose, but had you chosen, it would have been correct, and we'll give you the benefit of the doubt.
Yeah.
And that's convoluted logic to me.
Yes, it is. It is.
And it seems to me that not only is it convoluted, but the Supreme Court has sort of tied itself in knots, because instead of adjudicating what the government's done, they're virtually advocating to the government what it should have done.
Yeah, I mean, they've not put these words
as crudely as that.
Yeah, I mean, they've said this is how it is.
So, as a former very highly regarded judge of the Supreme Court, you're rather unhappy with the way the Supreme Court has handled this issue of abrogation.
Yes, I am unhappy, because I'm not sure, how they've come to certain conclusions. And certain conclusions, they've, like this Constitution of India can be applied in full. How have they come to that conclusion?
They sort of asserted it.
Yeah, you're right, it's like an assertion. They've also come to the conclusion, I think like in paragraph 400 or something, or 423 or something, that Article 370 could be abrogated. How did they come to that conclusion?
Again, they've asserted it.
Yeah.
So, just to sum up this bit of the conversation, you're unhappy with the way the Supreme Court has handled the abrogation of Article 370. And what they've done is they've provided grounds for actually striking down the abrogation, because they say that the interpretation of Constituent Assembly as Legislative Assembly is ultra-vires, but they haven't actually taken that to its conclusion. Instead, they found an alternate method, which the government didn't deploy, but nonetheless they said that if you had deployed it, it would be correct, therefore we'll give you the benefit of the doubt. And therefore, it's a very strange case where actually the logic of their position should have struck down the abrogation, but they've ended up doing exactly the opposite, because they've posited there's another way of doing it, which they've simply asserted.
Yes, and like you said, they've simply asserted it without giving reasons which I'm satisfied about.
So this is not just a position you're unhappy with, but this is a bad judgment.
I wouldn't say it's a bad judgment, but I'm not satisfied with the reasoning given.
Let me put it like this. It's neither clear nor convincing.
Yes, you could say that, yeah.
Let's now come to a second part of what the Supreme Court had to handle. Its refusal to determine whether the reorganization of the state was permissible under Article 3. In layman's language, whether the government had the power to demote Jammu and Kashmir from a state to a union territory. Now here it seems to me the court has relied on three separate arguments. The first argument, and I'll quote from the judgment, is, "We do not believe that the court ought to sit in appeal over every decision taken by the President during the imposition of Article 356. Because if every action taken by the President and Parliament on behalf of the state was open to challenge, This would effectively bring to the court every person who disagreed with an action taken during President's rule. Do you accept that as a legitimate reason for not determining whether something the government has done, reorganization in this case, is constitutional?
Yeah, you see the passage that you have read. Sorry. I don't know in what context they're saying it, because what was the argument advanced by the petitioners?
They don't say.
They don't say that. Now to find out what is the argument, you'll have to go through, it'll take 5 minutes to figure out what is the argument. So I really don't know in what context they said that. But you see, normally, forget about reorganization or any such thing. Any decision taken by the government, if it is wrong, it can be challenged, right? Now, I don't see any reason why, if a decision is correct, somebody would want to go to court and say, that I think it is wrong, even though it is right. So I would say that this kind of a sweeping statement that has been made, I'm not sure about the context in which it has been said, and I'm not sure whether the Supreme Court was trying to lay down a law that, listen, just because President's rule has been imposed, therefore you cannot challenge any decision.
But it's even worse, isn't it, Justice Lokur? They're deferring, or actually not taking up, a duty that is incumbent on the Supreme Court.
Yeah.
It is the Supreme Court's duty to sit in appeal over every decision if that decision is challenged.
Correct.
But they're saying exactly the opposite.
Correct.
They're saying it's not our duty to sit in appeal over every decision. Otherwise, we'll be sitting in appeal every time someone comes to challenge something.
Yeah.
But if everyone comes to challenge something every time, it's your duty to sit in appeal.
Yeah. You see, I think it was an error, if I may use that expression, by not deciding the reorganization aspect, that is the breakup of the state of Jammu and Kashmir into 2 union territories. That was an issue that was directly before the Supreme Court.
Which they ducked.
Which they did not decide, but they said that it will be decided in an appropriate case whether this can be done. Now, this was the most appropriate case as far as I can understand.
Yes, absolutely.
Now, if it was the most appropriate case, or if it was an appropriate case where this question had arisen, and in fact the Supreme Court did say that this question arises, they should have answered it.
They seem to have, if you read their judgment, produced a second reason for not determining whether the reorganization of Jammu and Kashmir was done constitutionally or not. Here they're referring to specifically the requirement under Article 3 for a recommendation from the state legislature. And they say it's not binding on Parliament. And therefore they say, because it's not binding on Parliament, just because it's not available doesn't stop Parliament acting. Now, it may not be binding, and I agree, but it's a stipulation specifically mentioned in the Constitution. And even though the Constitution says it's not binding, the Constitution does say that's a requirement, a process you have to go through. So can you circumvent a stipulated process in the Constitution just because it's not binding?
No, you see, again, this is where, there's a problem. Now, if the recommendation of the Legislative Assembly is necessary, right?
Which it is.
Which it is, yeah, I'm assuming that. And the governor is acting on behalf of the president, and the president can, it takes over the functions of the Legislative Assembly. The president could have made a recommendation. Okay. Then you would not have to circumvent Article 3. Now, for the purposes of 370, they say that there's a recommendation from the president. Now, if there's a recommendation from the president for Article 370, the president could have given a recommendation for the purpose of Article 3 as well.
Which he didn't.
Which apparently he didn't. Okay. So
here, by the way, their logic is at odds with each other.
Yeah.
What they say in one case, they don't say in the other.
Correct. Now, if that was so, if the president did not give the recommendations so far as Article 3 is concerned, then you decide it and say that, well, there's no recommendation from the president, and so therefore we do not agree.
Although here I think they've taken the opposite route. They say there's no recommendation from the State Assembly because the State Assembly no longer exists. But they say the State Assembly recommendation is not binding. Because it's not binding, it's therefore not necessary. The president can act on his own. But the Constitution specifically stipulates it's necessary.
Yes.
And my question is a very simple one. Just because it's not binding doesn't mean you can circumvent a constitutional stipulation.
Yeah.
Because the Constitution may well have hoped that even though the recommendation is not binding, it still could change the thinking of Parliament.
Yeah.
That opportunity to change the thinking of Parliament was denied by saying, we don't need the recommendation, we'll do without it.
Yeah. But that makes it easier for them to decide, no?
So once again, this is another area where you're unhappy with what they've done.
Yeah. According to me, they should have decided the reorganization question. It was the most appropriate case, and they should have decided it.
Absolutely. Yeah. Not deciding it is irresponsible, actually.
Well,
or dereliction of duty.
Well, you could say that it's wrong. They should have done it. I don't want to use this.
I agree, but it was also incumbent on them to do it.
Yeah, it was incumbent.
So it was a duty that they didn't fulfill.
Yes.
Right?
And the reason that they've given that let's wait for a more appropriate case, I don't think is not a good enough reason.
It's a bizarre reason. What better case can there be than this?
Yeah.
And the argument that the recommendation is not binding, therefore we can do without the State Assembly's recommendation, is a misreading of the Constitution. It's disregarding what the Constitution has stipulated.
Yeah. You see, because this sort of a situation may not arise in any other case.
Absolutely. Now, the third reason, and here I'm reading between the lines, for not determining whether the reorganization of the Jammu and Kashmir Assembly is constitutional, lies in a statement that they made. The court said, restoration of statehood shall take place at the earliest as soon as possible. And because they believe they've given that advice, therefore there was no need, I assume, to look into the matter. Because anyway it will happen, so why look into it now? But that's a bizarre way of, again, approaching a problem.
Yeah. You see, it would mean that Parliament would have to pass a law, right? Now, I don't think any lawyer can give a statement to the court on behalf of Parliament. All right, so that statement should not have been accepted.
And also, sir, this claim that it should happen at the earliest as soon as possible is vague and undefined. As soon as possible and at the earliest could be 5 days, 5 months, 5 years.
Yeah. Frankly, I don't think that statement should have been accepted.
So once again, just as you were unhappy with the way the Supreme Court handled abrogation of 370, you're equally unhappy, or maybe even more so, in the way they failed to look into the reorganization of the state.
Yeah, I'm repeating it. They should have looked into it. You know, where is the question of saying that you pass a law and grant statehood? You got a problem before you.
Here, your unhappiness is even greater, I sense.
Yes, you could say so. Yes.
Now, one consequence of the Supreme Court refusing to determine whether reorganization of Jammu and Kashmir was constitutional is that this process of reorganizing, this method of doing it, can now be used again and again because a precedent has been set. Tomorrow or day after, if the government were to choose, say in the case of opposition-ruled states like Bengal, Tamil Nadu, Kerala, to first impose president's rule, then transfer the powers of the assembly to parliament, and thereafter parliament decides to either abolish the state altogether or reduce it to union territory status, well, the precedent is set.
Yeah, theoretically, yes.
And how come the Supreme Court didn't realize that they are, through their lapse, allowing a precedent to be set that could endanger Indian federalism?
Yes, you're right. You see, it's possible that supposing Parliament does this, all right, take any particular state and they say we're converting that state into 2 union territories. And it's challenged before the Supreme Court, and the Supreme Court says, well, there's no recommendation of the state legislature, and even if there is,
it's not binding.
It's not binding upon us. So therefore, the division of this particular state into 2 union territories is okay. And we record the statement of the Solicitor General or the Attorney General that at some point of time, statehood will be given back to that particular state, right? And the question whether it is constitutionally valid or not, we will decide it in another appropriate case. So you wait for a third state to be divided. When the third state is divided, then you say, well, we'll wait for the fourth state.
In other
You
words,
know?
they are now hoist by their own petard. The logic they've used once, they might be required to use again and again and again.
Yeah. Yeah, that's why I think they should have decided it, right or wrong. I mean,
Do you think they realize the import of what they failed to do?
they should have. They should have.
Because it stares them in the face.
Yeah, they should have. Yeah.
And there was endless commentary in the papers for 3 or 4 years that what has happened in Jammu and Kashmir, if it is upheld, sets a precedent for doing this
Yeah.
in any other state.
Yeah.
In fact, the second consequence is precisely what I'm talking about. It was a point made out by Alok Prasanna Kumar, writing the Indian Express on the 13th of this month. He points out that federalism has been accepted by the Supreme Court itself as part of the basic structure of the Constitution.
Yes.
That means federalism cannot be amended. But the power to reorganize a state has now been accepted by the Supreme Court as a parliamentary power.
Yeah.
So don't we here have, at least incipiently, a clash between the power of Parliament on the one hand and the sanctity of the basic structure of the Constitution on the other?
Yeah, there is a problem. You see, in the past, Andhra Pradesh, for example, or Bihar and Jharkhand, or Madhya Pradesh and Chhattisgarh, they were done on the basis of recommendations made by the Legislative Assembly. Okay, so that's fine. But now, what the judgment says is that that's not even necessary.
Quite right.
Okay, so if it's not necessary, then what happens to federalism?
A nasty government, and maybe the word nasty is a bit editorializing, but a determined government can say, we don't need the recommendation of the state. We're determined to teach the government in Bengal, Tamil Nadu and Kerala a lesson. We will declare President's rule. We will then use the power of Parliament, which has assumed the power of the Assembly, to divide the state in two and reduce both halves to union territory status. And there's nothing anyone can do because the Supreme Court has set a precedent.
Yeah.
Which is why Mr. Kumar, Alok Prasanna Kumar, says federalism has been effectively threatened by what the Supreme Court has decided in this case.
Yeah.
You agree?
Yeah. Except that the Supreme Court will have to decide it. I mean, if they keep shirking the
Well, if they've
decision.
shirked it once, they can shirk it again and again and again.
Yeah, correct. That's why I keep saying that they should have decided this. Jammu and
And
Kashmir.
presumably, if they're going to decide it, they now need a 7-judge bench to decide it.
Not necessary, because they've said that it can be decided in an appropriate case. So 5 judges can say, well, this is an appropriate case. So we are deciding it.
Except they have to first agree that the case is appropriate.
Yeah.
I mean, the most appropriate case is the one they consider not to be
Absolutely.
appropriate.
Absolutely.
Who knows what they consider to be appropriate?
Yes, absolutely. Yeah.
The Hindu makes a further point.
Yes.
And I want to raise that with you. They made it in the leader that they wrote on the 12th. They say, and I'm quoting, the Supreme Court's judgment suggests the unconscionable conclusion that Parliament, while a state is under President's rule, can do any act, legislative or otherwise, even with irreversible consequences, on behalf of the state legislature. And then the leader continues, this may have grave implications for the rights of states. It undermines federalism and democratic processes to a frightening degree. As I read that, it seems to me that the Supreme Court has effectively opened a Pandora's box of problems.
Yeah, you see, if you think about it, what are the kind of irreversible decisions that can be taken? One irreversible decision that can be taken is the dissolution of the assembly, okay, which happens. Another irreversible decision that can be taken is the breakup of the state. All right. I can't think of a third irreversible decision. I mean, except hanging somebody or something.
Keep the state intact, but demote it to union territory status.
Yeah. What has happened in Jammu and Kashmir? And the third, I mean, if you say, hanging somebody, irreversible, yes. I can't think of any other thing which is irreversible. So, therefore, what the Hindu seems to be saying, in my view, is with reference to what happened in Jammu and Kashmir. Okay, so you have created an irreversible situation where you have broken up the state into two union territories. You can't put them back, right? Why? Because the Supreme Court says that this is not an appropriate case. Now, the question is, could the Supreme Court have said that, well, this is unconstitutional? Of course, the Supreme Court could have said that. And if it had said that, well, the Reorganization Act goes. And it comes back to statehood.
And just to go back to what we discussed earlier, the Supreme Court actually had good reason for saying abrogation is unconstitutional, because they said interpreting Constituent Assembly as Legislative Assembly, which is the mechanism the government used, is ultra vires.
Yeah.
So if they followed their own logic, they should have said, your act of abrogation is unconstitutional. You've used the wrong way of doing it.
Yeah.
Whether there's another better way of doing it is now for the government to discover later on, not for the Supreme Court to advocate it to the government in a sense.
Yeah. The Supreme Court has not advocated it. I mean, they have...
They found a way of saying, if you've done this, we'd have accepted it.
Yeah. Not that we would have accepted it, we are accepting it.
Yeah, we are accepting it, which is even worse. Yes.
Yeah.
As I said, what you did the wrong way, but there was another way of doing it that would be right, and we'd accept it on the grounds that there is a way of doing it that's right. But that's not the way the government did it.
That's not the way the government did it. That's not, I think, the way the government intended to do it. And I think the reasoning of the Supreme Court in that is incorrect.
This is why I say it's a bit like putting arguments in the government's mouth, because it's not the way the government intended to do it. But the Supreme Court saying, speak this way, and you're saying the right thing.
Yeah.
So, right at the end then of this interview, let me ask you, after our discussion, what is your final opinion of the Supreme Court, both in terms of the handling of Article 370 and its abrogation, and in terms of reorganization of Jammu and Kashmir? You began by saying this is a complicated judgment. It's probably 200 pages too long, right? And it's often inconsistent. But now that we've been through it in somewhat more detail, what is your final opinion of this judgment?
Well, I think the Supreme Court should review it. I'm pretty sure that some of the petitioners will apply for a review, and the Supreme Court should actually look into it. And what they have done, like I said, I'm not satisfied with the reasoning.
Is this a low moment for the Supreme Court in terms of judgments they've delivered on critical issues?
I wouldn't say it's a low moment, but it's not a moment that I would be proud of. Let me put it like that.
The Supreme Court should not be proud of its Kashmir judgments.
Yeah. Or at least I, as a citizen of India, am not proud of.
And that also means that the Supreme Court, you believe, has erred grievously.
It has erred. Grievous is a matter of opinion.
But it's erred.
It's erred, definitely. Yeah.
So this is not a judgment the Supreme Court should be proud of. It has erred. It should review it.
Yeah.
All three are correct.
Yeah.
Justice Lokur, thank you very much for taking us through and for making so simple for laymen to understand what is actually a very complicated, complex, and I would add, confusing judgment at times, where quite often what the Supreme Court does conflicts with what the Supreme Court's logic suggests it should do, Article 370 being a prime example. I thank you for having made it so much easier for people to understand.
Thank you.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on The Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.